Hello, and welcome to another exciting episode on the Law Lab. Here we dissect and unpack everything legal. My name remains Aaron Asiedu Entry. Just as we've always been doing, today we are as well looking at the law of contracts, and we are continuing from where we ended, i.e., the termination of an offer. And today we are looking at the third element. Some may say the second element of a valid contract. That is intention to create legal relation. Intention to create legal relation. I think many at times starting this law of contracts on this platform, that is the Law Lab platform. Clearly, I was doing it with my very good friend, Daniel Odro-Minta. I guess most of you are asking yourself, where is Daniel Odro-Minta? Daniel is currently out of the jurisdiction for an assignment, and I'm sure when he's back, he would be back with us to continue from consideration and other topics, i.e. terms, privity to contracts, and we'll move on to the vitiating factors, deal with discharge, and also the remedies that is available after the breach of a contract. And so today, I am the one going to take you through the topic intention to create legal relation. We mentioned in our previous episode that when it comes to making a formal or a valid contract, there are basically either 4 or 5 elements dependent on how you see it. We mentioned offer, we mentioned acceptance, which people do treat it together, that is offer and acceptance. And we mentioned that the next element you'll be looking at is intention to create legal relation. And the next one we would consider is capacity to contract, and the almighty consideration would come to make the contract a valid contract. Just as I mentioned early on, we are today focusing on intention to create legal relation. So from readings from Sir Frederick Pollock on his book, Pollock on Contract, the third edition of it, he clearly tells you that intention to create legal relations should be treated as a separate element in making a valid contract. In the sense that when I'm contracting, let's say Kofi is contracting with Amma, there should be that underlining tone whether Kofi intends to create a legal relation with Amma or Amma intends to create a legal relation with Amma. When we talk of intention to create legal relation, ladies and gentlemen, basically it means that as I am entering into contract with you, or as Kofi is entering into contract with Amma, the main thing they are looking at is that in any circumstance, should Kofi breach any of the obligations or the promises he has made, there should be that opportunity for Amma to bring an action for breach of promises or breach of the contract in a law court. And so basically, when we talk of intention to create legal relation, and if you are reading from Sir Frederick Pollock's book on Pollock on Contract, and I'm specifically stressing on the 13th edition, you get to know that Sir Frederick Pollock advises or admonishes that we should treat intention to create legal relation as a separate element in making a valid contract. And so basically today, this would be our outline. Just as we've been able to understand the essence of what intention to create legal relation is, the next thing we'll be looking at is that we will consider two main contracts, two main forms of contracts. And we'll take these two main forms of contracts seriatim, one after the other. Basically, when we have two main forms of contracts, we have one which is having a commercial or business undertone, a contract in a commercial or business setting. And the second one is a contract in a social or domestic setting. The law imputes some presumptions we must know under both circumstances or both forms of contract. Let me repeat again. We have two main forms of contracts. One, we have a contract under or that is actually carried out with regards to a commercial or business setting. commercial or business setting. And the next one is a contract carried under a social or domestic setting. And so the next stage of our video today, or on this episode, is to consider the presumptions made under these two forms of contract. So now let's start with the contract put under a commercial or business setting. Now there is this general presumption of the law that a contract carried under a business or commercial setting, the law presumes an intention to create legal relation between the parties to the contract. So anytime Kofi enters into a contract with Amma, in a business or a commercial setting, the law presumes an intention to create legal relation between these two parties, i.e. Kofi and Amma. And this principle is clearly espoused in the case of Edwards versus Skyways. In the principle of Edwards versus Skyways. Now let me come back to the first form of contract. That is a contract under a business or commercial setting. Just as I mentioned that it is clearly espoused in the case of Edwards versus Skyways Limited. Edwards versus Skyways Limited. That the law says that any contract under a commercial or business setting, there is that presumption to create legal relation. Now the point is, some parties may believe themselves so well and have so much belief in themselves that these contracts, or let's say I've known my very good friend Daniel very well, and I would have that presumption that, or I would think that entering into contract with Daniel, I've been working with Daniel for, let's say, the past 10 years, and I know he's been honoring his promises. So the parties can clearly put out in a contract that they do not intend to create legal relations. So because I have known Daniel for 10 years and Daniel has been actually dealing with me on a very good basis, and I know Daniel will honor his promise, I can put in that contract that we do not intend to create legal relation. And such clause placed in the contract is called an honorary clause, an honorary pledge clause, an honorary pledge clause. In that particular instance, when I make that bold statement or both parties make that firm statement or put that clause in our contracts by stating that we do not intend to create legal relation, remember, based on the principle of freedom to contract, I believe you've watched our videos, so you should know how we discuss the principle of freedom to contract in our first video under the nature and essence of contract. You get to know that parties must actually contract under their own free will. And so if under our own free will, a contract between myself and Daniel, we are saying that we do not intend to create legal relation, the court will not impute an intention to create legal relations, but however uphold whatever thing that we stated by stating that this contract, we do not intend to create legal relation. So even if Daniel breaches the contract or myself, I breach the contract, the court would have no locus to actually hear the matter. And a case to help us understand this principle is Rose and Frank Company Limited versus Crompton Brothers. Rose and Frank Company Limited versus Crompton Brothers. What happened in this case? In the case of Rose and Frank Company Limited versus Crompton Brothers, the defendant's company was a firm established in England which manufactures tissue papers. A firm established or that was stationed in England or incorporated in England and which manufactures tissues. And these firms made the plaintiff company the sole company responsible or their sole agents in the United States of America. And they now place in their agreement that they have this, what we call the honorary pledge, that both parties do not intend to create legal relation. And so in one of their transactions, The defendant firm did not supply the goods to them, which breached some contractual obligations between these parties. And the plaintiff brought an action for the breach of contract and also the breach of delivery of some specific goods they have ordered. The court on the first instance, which is the breach of the contract, stated that because you have clearly stated in your agreement that you have an honorary pledge clause, which means that you do not intend to create legal relation. We as a court, based on the principle of freedom to contract, cannot impute that presumption that you intended to create legal relation, because you have clearly stated in your contract that you have an honorary pledge clause that you do not intend to create legal relation. However, on the second relief the plaintiffs were seeking, which was clearly based on the non-delivery of some specific goods, the court stated that that creates a separate contract from the main agreement, which had the honorary pledge clause. And in that essence, the court stated that for that bit, they will grant or they will presume that the parties intended to create legal relation. However, the main agreement, which deals with the breaches that the plaintiff company was seeking, the court stated clearly that because they have placed the honorary pledge clause, the court clearly has understood that they do not intend to create legal relation, which is firmed up on the principle of freedom to contract. I believe having a clearer understanding, and if you're also to read the case of Jones versus Venom's Pools Limited, you get to know that where the pools company stated that any pool you make, they do not intend to create legal relation. The court upheld that where the defendant's company failed to even pay you back, you clearly actually had that clause in your agreements, and that since they do not intend to create legal relation, of which you agreed based on the principle of freedom to contract, because you were not forced into the contract, you did not enter into the contract under duress, under any vitiating factor, and you entered into the contract based on your own free will, then you do not intend to create legal relation. Last, on the first form of contract, which is the contract under commercial or business setting. Don't forget that I stated that the general principle under this is that first, the parties intended, or there is that general presumption that the parties intended to create legal relation. Second, we move on to deal with the honorary pledge clause, which stated that for that, where the parties, based on the principle of freedom to contract, clearly states that they do not intend to create legal relation, then clearly the court will uphold it because of the principle of freedom to contract. The last subheading or sub-concept I want us to consider under the commercial or business setting is, in some circumstances, parties would also have an agreement where they do not clearly state in the agreement that they do not, or they have an intention to create legal relation. The clause on intention to create legal relation sometimes is silent in the agreement. What would the court do when they are presented with such issue? The position of the law is that the court will consider the whole contract, the contract as a whole, and clearly examine using the objective test to actually determine whether the parties were contracting under a commercial or business setting. And if indeed they were contracting under a commercial or business setting, the clear case, or clearly what will happen is that the court would impute an intention on them that they intended to create legal relation. All that I'm saying under this last concept, under the business or commercial setting contract, is that where there is an agreement between two parties, say Kofi and Ama, and they did not expressly state in the agreement whether or not they intend to create legal relation, the position of the law is that the courts would now use the objective test. Remember, we have explained what the objective test is in our first video. That is the nature and essence of contract. And remember that my good brother Daniel Odro Minta mentioned in that video that law of contract is not disjunctive. It is not disjunctive, it is conjunctive. So we build upon whatever thing that we've learned in the past. And so based on that, the court will use the objective test to determine whether the parties were contracting under the commercial or business setting. And if indeed the court is to settle on the fact that they contracted under a commercial or business setting, the court will now impute an intention to create legal relation. You know, contract law, the principles goes hand in hand with case laws. And so let's consider the case of Hammond versus Enusen. Hammond versus Enusen. I believe you know that just as our practice, the case will be rolling on the screen. What happened in Hammond versus Enusen? In Hammond versus Enusen, the defendant owned a boat, and he told the defendant had an oral agreement with the plaintiff that if you are able to supervise the servicing of my boat, I will make sure that you will be in charge of the sale of all fishes that will be caught by my boat. That was an oral agreement. The plaintiff actually pushed the defendant to actually reduce the oral agreement into writing, but the defendant refused to do so. Remember, we've mentioned in our previous videos that Section 11 of Act 25, that is Contract Act 1960, Act 25, clearly mentions that a contract can be in writing, it can be oral or partly written or partly oral. Whichever form it takes, that contract is enforceable. So the fact that the defendant in Hammond versus Enusen was only making an oral contract does not mean that that contract is not enforceable. And so through that oral contract, the plaintiff also agreed to the fact that I would supervise the servicing of the boat. I will supervise the servicing of the boat. And indeed, he supervised the servicing of the boat. But unfortunately, the defendant passes back and actually contracted a third party to be in charge of the sale of fishes that the boat caught. The plaintiff brought an action in court, and the court said that since you did not have what we call an express provision in your agreement talking about whether these two parties or you, the parties, would have an intention to create legal relations, the courts actually use the objective test to determine that the parties were actually contracting under a commercial or business setting, and they impute legal relation between them, and stated that since per the objective test, they intended or they were contracting under a commercial or business setting, they intended to create legal relations. Now, this brings us to an end to the first form of contract, that is a contract under a commercial or business setting. Now, let's consider the second form of contract. I mentioned to you early on that there are two forms of contract we will be considering. One with commercial or business setting, and that has been thoroughly discussed. Now, let's look at the second one, a contract under social or domestic setting. Social or domestic setting. Now, what is the general presumption of law of a contract under a social or domestic setting? The general presumption of law is that there is a rebuttable presumption that parties who contract under a social or domestic setting do not intend to create legal relation. There is a rebuttable presumption that parties who contract under a social or domestic setting do not intend to create legal relation. If you clearly listen to me, this principle, let me first mention an authority to support this principle. That is in the case of Coward versus Motor Insurance Bureau. Coward versus Motor Insurance Bureau. Clearly, you should now get to know the difference that under the first form of contract, that is contract under a commercial or business setting, I mentioned that there is a presumption that a parties intend to create legal relation. However, a contract under a social or domestic setting, there is a rebuttable presumption that the parties do not intend to create legal relation. So ordinarily, the presumption is that a contract under a social or domestic settings, parties do not intend to create legal relation. But that presumption is rebuttable. And so as we move ahead, we will consider some of the instances where a contract is made in a social or domestic setting, and also consider at what point in time would that presumption be rebutted. And so the first form of social or domestic contract we mostly have in our homes is a contract between a husband and wife. And also we consider a parent and child. When I get to the parent and child, I'll share a very nice experience I had with my mom when I was writing my BEC exams. But first, let's consider the presumption, or in what instances, just as I've mentioned, that a contract between a husband and wife is a contract under a social or domestic setting. So the general principle, as Coward and Motor Insurance Bureau actually taught us, is that there is that presumption that the parties do not intend to create legal relation. However, after considering this principle between a husband and wife, we will consider case laws that is attached to it, and also look at instances where this presumption can be rebutted. Now let's consider the circumstance between a husband and wife. Let's consider the case of Balfour and Balfour. What happened in the case of Balfour and Balfour? In the case of Balfour and Balfour, the husband and wife were in this kind of relationship, or getting to a point that they were on the verge of breaking up. And so they were forced to live apart. That is where what we term in our local parlance as separation. And so the husband promised the wife that he will be maintaining the wife £30 each month for maintenance. Just as mentioned, he would maintain him with £30. That was a promise he made. I think at a point in time, the husband stopped sending that money, and the wife brought an action, and the court said that a contract in a social or domestic setting, which clearly is between a husband and wife in this particular case, the parties do not intend to create legal relation. The presumption of the law is that the parties do not intend to create legal relation. At what point would a contract or an agreement between a husband and wife, the court will presume that there is an intention to create legal relation? Meaning, at what point would this presumption that has been held in the case of Balfour and Balfour be rebutted? Let's consider the case of merit and merit. The position of law in merit and merit is that where the agreement is between the husband and wife, though in a domestic or social setting, if these parties, that is the husband and wife, are not living in amity, there is that presumption that they intend to create legal relation with whichever agreement they will enter into. So where the husband and wife are not living in amity, the court presumes that they intend to create legal relation with regards to any form of agreement they enter into. Now, we've all learned in Balfour and Balfour that an agreement between a husband and wife is one in a social or domestic setting, and that there is that general presumption that the parties do not intend to create legal relation. Don't forget that in Coward versus Motor Insurance Bureau, I mentioned to you that this presumption we are making under social or domestic setting by the law clearly states that it is a rebuttable presumption, meaning the general presumption held in Balfour and Balfour can be rebutted. And now let's consider in what circumstance would this presumption be rebutted. And the circumstance in which this presumption will be rebutted can be considered in the case of merit and merit. In merit and merit, the court held that an agreement between a husband and wife, though in a social or is in a social or domestic setting, where the husband and wife are not living in amity, the court or the law presumes that they intend to create legal relation with regards to any agreement or contract these parties enter into. And now let's consider what happened in merit and merit. Here, the husband promised that he'll be giving the wife some £40, I think monthly, and also the wife should also make payment for the mortgage they have entered into. Though the mortgage was in their joint names, the wife went ahead, made payment for the mortgage, and now the husband is saying that this agreement is one of social or domestic nature, and that as such, the law is saying that we do not presume, we do not intend to create legal relation. Now the court is saying that since you are not living in amity, the presumption is rebutted, and that the court will presume that indeed you intend to create legal relation. Now let's consider the most famous or popular agreement in social or domestic setting, a contract between a parent and a child, where somebody comes to the house, give this to Joe, the mother takes the money, puts it in her pocket. I remember when I was going to write BEC, my mother promised me, Aaron, when you are able to pass this BEC, I'm going to buy a mobile phone for you. Just as we are sitting here, I'm yet to receive the mobile phone since some over 15 years or so that I start to write the BEC. Now, the point here is that the court is saying that an agreement between a parent and a child, there is no intention to create legal relation. May consider the case of Jones versus Padavatin, where the mother told the daughter who was living in US and working in US that she should come to the UK and actually learn law or read law. The daughter reluctantly agreed to it. The parent or the mother bought a house, and actually the daughter came to stay in. The daughter, after doing about part one of her studies in reading the law, the parents, there was some sort of disagreement between the daughter and the parent. And the parent is saying that she is claiming possession of her mortgage. And the court is saying that you cannot claim possession because an agreement between yourself and your child, there is one of social or domestic character. And as such, both parties, you did not intend to create legal relation. Now, this same presumption is rebutted when it's between, though the agreement is within a social or domestic setting, but between unrelated parties. Unrelated parties. Let's say Party A is not really related to Party B. Let's consider the case of Simpkins versus Pace. Simpkins versus Pace, where we have three people living in a house: a grandmother, a granddaughter, and a third-party tenant. And mostly they were actually involved in this pool game. And what happened is that they actually registered the pool in the tenant's name. I got to a point that the three of them will play in the tenant's name and they will share the money when they win the pool. Got to a point that one day they played the game, they won, and the defendant is saying that this is an agreement in a social or domestic setting, so I'm not going to give you the money since we do not intend to create legal relation. The court is saying that where the parties are unrelated, the court presumes that they intend to create legal relations. People, ladies and gentlemen, today clearly we have looked at intention to create legal relation as a separate element for a valid contract. I started by mentioning to you that Sir Fred Pollock, in his book Pollock on Contracts, I am specifically talking about the 13th edition. He mentioned that intention to create legal relation should be treated as a separate element in making a valid contract. And I mentioned to you that one of the most simplest way of understanding intention to create legal relation is that, let's say Aaron contract with Daniel. The point here is that anytime that Daniel or Aaron breaches a provision or an obligation in the contract, Daniel should have that intention, or the both parties should have that intention, that if either of them breaches it, the one who has been affected by the breach can actually bring an action before the court. That is the intention to create legal relation. And I'm said that we have actually learned that for us to actually understand this intention to create legal relation well, we must consider it under two broad main forms of contract. Two broad main forms of contract. One, a contract under commercial or business setting, and two, a contract under social or domestic setting. And I mentioned to you that when we pick contract under commercial or business setting, all that we are saying is that the law presumes that anytime a party contracts under a commercial or business setting, there is that intention to create legal relation. We consider the case of Edwards and Skyways, and where parties contract under the honorary pledge that I believe in this gentleman, anytime I enter into contract with him, he does. So for this our contract, we do not intend to create legal relation. The court is saying that based on the principle of freedom to contract, they will uphold it and actually not actually have locus to even look into the matter. We consider the case of Rose and Frank Company Limited versus Crompton Brothers. And we said that where the parties do not expressly state in the agreement that they intend to create legal relation, the court will use the objective test to determine whether they were under a business or commercial setting, where we consider the case of Hammond and Innocent. We proceeded to consider social or domestic setting contracts. And we mentioned that the general position of the law is that there is a rebuttable presumption that the parties do not intend to create legal relation. We consider the case of Coward versus Motor Insurance Bureau. Coward versus Motor Insurance Bureau. Then we moved ahead to consider some forms of domestic or social contract. And we are saying that one of the forms is a contract between a husband and wife. And Balfour will tell you that the general presumption goes, the parties do not intend to create legal relations. However, this presumption is rebutted in the case of merit and merit, where when the parties, that is the husband and wife, are not living in amity, then the court will presume that they intend to create legal relation. Now we moved ahead to consider a parent and child. Don't forget that I shared my experience with my beloved mother. I love her so well, Christiane Obobi. She promised me a phone, and up till now, she's not bought it. Even when I'm to take her to court, I think that she would only hide under Balfour, or the case of Johnson, Padavatin, and get away with it. So I'm not even bothering myself to take her to court. But the point is that a contract or an agreement between a parent and child, there is that general presumption that the parties do not intend to create legal relation. And we consider the case of Jones and Padavatin. And now we move ahead that this presumption is also rebutted when the parties are not related, where we consider the case of Simpkins versus Peace. Even on the same principle, you may consider the case of Parker and Clark, or Hammer and Sidway. Parker and Clark, or Hammer and Sidway. Thank you very much, ladies and gentlemen, for sticking through with us in learning the intention to create legal relation as one separate element in making a valid contract. Kindly follow, like, subscribe, and share. Speak to a friend to speak to a friend that Law Lab is live with intention to create legal relation, and all other videos as we move ahead to dissect and actually digest the law on this platform. Remember, I've always been saying, do not take all your cases to God. Make sure you take some to your lawyers. The lawyers must chop. This is the Law Lab. We will appreciate your sincere feedback in the comment section. Thank you very much.